We're here for a hearing in docket SB 2015-06. This is for hearing outstanding motions. Specifically, we'll go through them. Could the parties identify themselves for the record, please?
Test. Works. Allan Shore from the firm of Politi Shea on behalf of Invenergy. With me today, Elizabeth Noonan, Nicole Birdy, Richard Barretto, also with our firm. And with the representative Invenergy today also, I have Michael Glaser, General Counsel for Invenergy, is here with us today, as well as John Iannotti with the company as well. Good morning.
Good morning. For the town of Charlestown, I'm David Matranga, and to my right is Peter Ruggiero.
Good morning. Andrew Marcaccio on behalf of the Rhode Island Office of Energy Resources.
Good morning, Mike McIlroy for the town of Burrillville.
Sherry Elmer for Conservation Law Foundation. With me at council table is Max Green, also of CLF.
Thank you. Are there any administrative matters? Oh. Judge.
Todd Bianco, board coordinator.
Thank you. We have 4 motions listed on the agenda for today. First is the town of Burrillville's motion seeking an order requiring an independent environmental impact document and appointing an independent environmental expert. The second is Invenergy's motion for protective treatment of confidential information contained in an attachment to the supplemental testimony of John Iannotti. And then there are 2 motions from the town of Charlestown, a motion for clarification or instructions and or an extension, and a motion for funding as an affected community. Is that everybody else is identified? And I would expect that we do them in that order. Is there any different order that the parties would like to suggest? And we'll begin with the town of Burrillville.
Thank you, Madam Chair. Burrillville has filed a motion asking this board to do 2 things. 1, to order the preparation of an independent environmental impact document, which would be similar to an environmental impact statement. And 2, to appoint an independent environmental expert to evaluate the adverse environmental impacts of Invenergy's proposed power plant. Invenergy's expert environmental witnesses have all filed testimony concluding that the proposed plan would not cause any unacceptable adverse environmental impacts. The environmental expert witnesses for the town and CLF have all concluded that the proposed project would cause unacceptable adverse environmental impacts. It is the town's position that this board should therefore have an independent environmental impact document prepared at Invenergy's expense, and should also appoint an independent environmental expert to evaluate the complex environmental issues in this matter. The Department of Environmental Management has stated in its advisory opinions that the majority of the environmental issues in this case, including the most severe environmental issues that need to be considered by this board, are not within the statutory jurisdiction of DEM or the Army Corps of Engineers. This $1 billion, 1,000 megawatt power plant would be the largest construction project in the history of the state of Rhode Island. The town submits that independent expert assistance in evaluating the environmental harms this project would present is needed for the public to have confidence in the eventual determination made by this board. The environmental issues in this docket are many, varied, and complex. For example, there are significant wetlands biodiversity issues, such as forest fragmentation, destruction and/or degradation of wetlands and special aquatic sites, and the loss and degradation of habitats used by many animal and plant species, and these include 17 state-listed species. The air pollution issues include 7.2 billion pounds of carbon dioxide and hundreds of thousands of pounds of other toxic emissions that would be emitted each and every year. There are traffic congestion, safety, and related issues. And as this board well knows, there are water supply, transportation, and related issues that have generated multiple water filings. If the town had confidence that Invenergy's environmental submissions to date were complete and unbiased, an environmental impact document and an environmental expert might not be necessary. However, as recently as November 10th of this year, the town learned that DEM had concluded that it was, quote, unable to complete our review of your application at this time, quote, because of well over 50 problems discovered in Invenergy's freshwater wetlands application. In fact, the problems are so severe that DEM has stopped its review and will not start the review again unless and until the information is furnished. The DEM letter is only the most recent example. Invenergy's environmental submissions to the town's zoning board, the town's planning board, and the town's building inspector have all been consistently deficient. Therefore, the town respectfully submits that this board cannot rely on Invenergy to submit complete and unbiased environmental impact information. This board has an established history of obtaining independent environmental documents and also retaining an independent environmental expert to evaluate whether proposed power plants would present unacceptable environmental harms. For example, in the Ocean State Power docket, this board stated, quote, an EIS is essential to the board's deliberations, quote. In addition, in the Ocean State Power decision, this board hired an independent expert saying that, quote, the best way in which to analyze environmental data is by the preparation of such data by an independent entity or, at a minimum, review of such data by an independent entity, end quote. In fact, this board in the Ocean State Power case went so far as to suspend the final evidentiary hearings until such time as the environmental impact statement, which was being prepared by the Federal Energy Regulatory Commission, had been prepared and reviewed by all parties. In doing so, the board stated, quote, since it would be futile to hold hearings at the present time without a draft, prudence dictates that the final hearing on the Ocean State application be suspended until such time that a draft is available and interested parties have had the opportunity to review the draft EIS, end quote. Similarly, in the Manchester Street Power Plant docket, this board stated that, quote, the preparation of a comprehensive environmental impact document, EID, similar to an environmental impact statement, EIS, is deemed by the board to be an essential step, quote, toward fulfilling the board's responsibility to, quote, evaluate all individual and cumulative environmental impacts, end quote. In addition, the board in Manchester Street retained an independent environmental firm, quote, as its expert environmental consultant to oversee the EIS process, end quote. Again, in the AES Riverside application to site a power plant in Woonsocket, this board determined that a comprehensive EID would need to be prepared that essentially replicated an EIS. Finally, in the Equipment Power Limited Partnership application to site a power plant in Portsmouth, this board also ordered the preparation of a comprehensive EID. while there have been other dockets, primarily involving transmission lines, in which this board has not ordered the preparation of an EID. In those cases, the complex biodiversity, wetlands, fragmentation, water, traffic, air, and similar environmental adverse impacts that are present in this case were generally not present in those other cases. There is no question that this board has the legal authority which it has exercised repeatedly in the past to order the preparation of an environmental impact document, as well as the hiring of an independent environmental expert to advise the board. I don't believe that's in dispute. That authority is set forth in Board Rules 1.12 and 1.21, as well as in RIGL 42-98-7 and RIGL 42-98-17. I won't go into detail on that authority because I don't believe it's in dispute. It is also important to note that we do not yet know whether the Army Corps of Engineers, which has federal jurisdiction over this proposed project, will require the preparation of an EIS. Based on the data responses submitted by Invenergy, it appears that the Army Corps is in the early stages of preparing its environmental assessment. The purpose of the environmental assessment is to determine whether an EIS will be required by the Army Corps. According to Invenergy, that determination was delayed due to design delays associated with the National Grid transmission line portion of the project. However, even if the Army Corps does require an EIS, the scope of the EIS would be limited to the aspects of the project for which the Army Corps has statutory control and responsibility. As DEM has made very clear in its advisories, the review by DEM and the Army Corps is limited to those areas within the statutory responsibilities of DEM and the Army Corps. But the most severe adverse environmental impacts and the majority of the ecological adverse impacts will occur in upland areas outside of the statutory jurisdiction of DEM and the Army Corps. This is what DEM's advisory stated in this regard. Quote, "The applicant indicates that many of the concerns that DEM raised in order to comply with the EFSB's orders will be addressed through the wetlands permitting process. Unfortunately, as previously stated in DEM correspondence, including DEM's advisory opinion, the permitting process under DEM's jurisdiction and outside of the EFSB process does not address some of the most severe impacts that would result from construction of the proposed facility." End quote. The DEM advisory goes on to give examples of such matters. These examples include assessment of forest biodiversity impacts and other impacts that have come to light during this process and occur outside of the designated wetlands. Other examples given by DEM are the threat of invasive species to wildlife and habitat and issues related to forest fragmentation. As DEM went on to say, quote, "The permitting processes to which the applicant would have the EFSB defer do not address forest loss and fragmentation, any loss of upland habitat, nor impacts to state-listed or otherwise at-risk species outside of the wetlands." The DEM advisory went on to state, quote, "The majority of the ecological impacts from this facility will occur in upland areas outside the scope of the wetlands permit and outside of the jurisdiction of DEM's Office of Water Resources, U.S. Army Corps of Engineers, and the U.S. Environmental Protection Agency. Further, since the majority of impacts relate to permanent loss of interior forests, they would be exceedingly difficult to mitigate despite of good faith efforts to do so." The DEM advisory concluded as follows, quote, "All of these landscape level assessments identify the subject parcel as being of high value for wildlife. The diverse number of plants and animals and the larger than typical number of state-listed species found prior to and during the single-season CREC survey support DEM's conclusion that this site has high wildlife value." End quote. This board has recently delayed the start of the evidentiary hearings for approximately 90 days. We have also recently discovered that there are 2 lawsuits pending at the Federal Energy Regulatory Commission regarding the unsigned interconnection agreement for the transmission line, the resolution of which could take months. Given the significance and complexity of the environmental issues identified to date, the town respectfully submits that an independent environmental impact document be prepared under the supervision of an independent environmental expert retained by this board, who would assist this board in fully carrying out its statutory responsibilities to determine whether this proposed project would present unacceptable environmental impacts. We need to remember that not only will this plant be the largest power plant in Rhode Island, but it will be one of the largest power plants in all of New England. This plant will, in all likelihood, if licensed, operate for 40 or more years. Therefore, before this board licenses such a facility, the town respectfully submits that the board should obtain an independent environmental expert to assist in the evaluation of these crucial issues. We understand that Invenergy opposes this motion. However, we ask you to consider the fact that Invenergy claims there will be no unacceptable environmental impacts. If Invenergy is so confident that its environmental experts are correct, why are they afraid of an independent evaluation? The town is urging you to conduct an independent environmental expert and evaluation because the town is completely confident that the findings of such an independent review will conclude that this project would cause unacceptable adverse impacts on the state's environment, and most particularly its land, its wildlife resources, the health and safety of its citizens, the purity of its air and water, and the aesthetic and recreational value of the land on which this proposed power plant would sit to the public. Thank you.
Madam Chair, members of the board, Invenergy opposes the request to have an EID in this instance or to have an independent expert appointed, as we believe it is unnecessary and an untimely request on behalf of the town of Burrillville. I reference back to the order of this board dated April 13th, 2017, when CLF had requested, and the town had requested, that the board hire an independent expert in regard to water. At that point, on page 2 of that order, I quote, "The board first addressed CLF's and the town's request that the board hire an independent expert, noting that in the past, an independent expert had been retained to address a critical issue that was not fully litigated by the parties. The board found that the current situation, where the major parties have retained numerous experts to address the issues at the final hearing, does not necessitate the board retaining its own expert." We are in similar situation today. The information that has been provided to this board is voluminous. I'm sure you're aware of that. And we recognize Invenergy, it is our burden of proof in this case. What you have been submitted to you is not only the information from Invenergy, which we have set forth in part at page 3 and 4 of our objection to this motion, but the information from the town of Burrillville, where they, as early as last year, had retained experts to review our information that was presented to the planning and zoning boards, as well as the filed and submitted testimony that has been provided to this board. Additionally, now the town of Charlestown is also involved in this process. Similarly, CLF has also provided submitted testimony to you, as well as the advisory opinions from multiple agencies. You have a wealth of information in front of you upon which to make your decision. This is a proceeding upon which the board takes the information and rules, and we would posit that the information provided to you provides what you need to make those decisions. And in this case, hiring an expert or ordering an EID would be unnecessary, and we also argue untimely. The issues that Mr. McIlroy has just gone through at length are not new issues. These are issues that have been front and center since the time the application was filed almost 2 years ago, and that have been presented at the town level and have been the subject matter of great number of data requests as well as the filed testimony. Why the town waited until November 17th to file this motion when hearing dates were scheduled for last Friday is I can't understand why they waited if they felt so strongly about it. An EIS has been discussed on many occasions amongst the parties and in motions, but yet no motion has ever been made regarding getting an independent expert for all environmental issues. The town has proffered no reason as to why it waited till the 11th hour for this request. In regards to some of the specifics that Mr. McIlroy discussed today, we recognize that there is the RIDEM permit processing that's going on, as well as the U.S. Army Corps of Engineer and this board. Those are the three agencies that are dealing with all of the scope of this application. RIDEM did issue a letter to the applicant. We're asking for a number of items to be completed. That was last November. We anticipate a response to those comments will be filed this week. They are rather, while this is a large project, the comments that are contained within that letter are somewhat of what DEM does. They take an application, they ask you to do it. A great number of them are very procedural, sizes of plans, where things should be. They address very specific issues to handle, including the water issue, as well as mitigation. Those issues are within the DEM jurisdiction, and we recognize that, and we also recognize that there are issues that fall outside the scope of that RIDEM permitting process. For example, the biodiversity issue does not touch directly on that permitting process. But for that issue specifically that Mr. McIlroy went on at great length, you have the reports from ESS and the testimony. The town has presented testimony from Mr. Zemba, and the Nature Conservancy has also weighed in on it. You have 3 different viewpoints already at this point. So it's our position that between the agencies tasked with reviewing each portion of this application, that you are provided with the information appropriate to render a decision after we've had final hearings. Finally, Mr. McIlroy points to prior EFSB proceedings where independent experts and/or EIDs have been ordered. Again, I reference back to your initial order in April of this year involving cases where there was no, that wasn't fully litigated. It talks about Ocean State Power and Manchester Street. Dockets were suspended in Ocean State Power at the request of the applicant. And in Manchester Street, these EIDs were ordered at the preliminary hearing stage, not on the eve of final hearings. So those cases are distinguished. We also reference them in our papers, and I rely upon our statements in there. In conclusion, I believe, again, as I said, that this motion is necessary and untimely, and we would ask that it be denied.
I think that no one else was involved with that motion, correct? CLF didn't provide. Mr. McIlroy, why should this motion be considered timely?
Madam Chair, it's a good question. We all along thought long and hard about whether we should ask for this. There are 2 main reasons that I'd like to bring to your attention. Number 1, there is no rule that says that a motion like this needs to be filed by a particular period of time. And what happened in this case was, as information was coming in, we were assuming that we were going to get complete information. We were sorely disappointed from the beginning of the process, but most recently with the November 10th letter. The November 10th letter from DEM identifying 50 areas of issues, putting the review of that application on hold, giving Invenergy 1 year to supplement its application before they would start the review back up again. This is what put us over the edge and led us to say, you know what, we really do need to have, for the board, I mean, this is not for us. Remember, we have, in fact, Ms. Noonan is correct, we have filed expert testimony on these issues, as has Invenergy. But we firmly believe that this plan is so significant that the impacts would be so environmentally devastating to the state that we think it requires a little bit more than a he said, she said. Then Invenergy saying no problem, and the town saying, and CLF saying big problem, and then this board having to try to decide based on the review of the evidence whether or not it is.
Although we're not simply being asked to rely on whether the attorneys take the position that there is or is not environmental harm that's not acceptable. we have experts. Are you suggesting that the experts are not competent to address the issue?
Not at all. But we do think that an independent review of the environmental harm would be helpful to the board and helpful to the public's confidence in any ultimate determination reached by this board. You've got two sides.
If we were to allow that, wouldn't that be an indication that the board has no confidence in the environmental experts that the town and CLF have already provided pre-call testimony for?
Not at all, Madam Chair. I believe that it would be seen as an exercise of prudence and independence by this board, that it wanted to get it right. Clearly, there are good experts on both sides. I'm not saying that the experts that have filed testimony to date are in any way unqualified. Absolutely not. But I am saying resolving these crucial issues is very, very important to the state of Rhode Island.
And isn't that's the role of the board?
It is, but the board in the past has made it clear in previous power plant cases that it thought an environmental impact document was essential to the proper exercise of its authority.
But I think that all of those cases are distinguishable from the present case in terms of the availability of expert testimony already filed, as well as the proceedings.
I don't think that's true, Madam Chair, because those decisions were made early on in those cases. Again, if there's there were 4 power plant cases in all that I cited. In all 4 of those cases, the decision was made usually at the preliminary hearing that they were going to require the preparation of an environmental impact document or an environmental impact statement if the feds had jurisdiction. And in 2 of those cases, they were going to hire an independent environmental expert to be the board's advisor in those matters. We think that it makes good sense. Remember, we believe there's no environmental harm. We believe our experts have proven that to you. However, we have...
No environmental harm? Is that what you want?
Obviously, I misspoke, and I apologize. We believe there
Make
is...
sure you correct it for the record.
Thank you. We believe there is significant, unacceptable environmental harm here. We're confident in that. We're so confident in that we have no fear whatsoever of asking this board to bring in an independent environmental expert to do a review, to make a recommendation to you as to which side is right. Is the town right, or is Invenergy right? We think that would be helpful.
Thank you, Mr. McIlroy. Does Invenergy have a response to that?
My only comment is based on Mr. McIlroy's analysis, this board could say there's no need for any testimony, just hire an independent expert to review applications and handle the process that way. I believe we do have competent expert testimony upon which we can rely.
I don't think I have any more questions for the lawyers, but I would just comment maybe in reaction to what you're saying, is I think the earlier cases are distinguishable and that there wasn't sufficient expert testimony in the record. I don't deny at all the appeal of what you're saying, Mr. McIlroy, but I do have confidence in the DEM and in some of the experts that you put forward, some of whom are the foremost experts in the state on upland habitat, forest, interior birds. So we have, as you mentioned, Ms. Noonan, you have the burden of proof, and we have the job of taking a look at all the evidence in front of us, including the comments from DEM and their experts about the wetlands. And even while that's a separate permit process, we will have DEM here and can question them. So a couple of thoughts. When I saw this, I thought, well, thank you for the recommendation, but I know we have that, and I think this is something we discussed before. We have the ability to hire experts where we think we need them, and we'll continue to have that ability if we should feel that some element of this case is not, needs further illumination. So we'll continue to have that. My feeling has been, from looking at the list of experts in the testimony, that we have some very solid experts involved that can give us the information that we're looking for in regard to upland impacts and other impacts. So I'm not sure that we need to rule on this motion. I was going to ask you, because we really have that authority. But my inclination would be for us.
I think we do have to rule on it since it's a filed motion.
I guess what I'm saying is whether or not we pass the motion, in other words, say that we don't have to vote to approve or deny, as opposed to voting, making a motion to approve or deny. That's my question to you, Madam Chair.
And that's council.
Okay, all right, so I guess that's mostly what, as I feel, I think you said you did too, Mr. McIlroy. I have confidence in experts, and I think that weighty decision does rest on the board to review the evidence before us and make that cumulative decision.
I agree with that, and I don't think that this is a timely motion. If the argument were that the motion has to be made now because the pre-filed testimonies come in and it's inadequate, and there's just no way that it's appropriate for proceeding to the final hearing, that would be a different case. I think it's not timely. I think that it would be an inappropriate addition of time required for preparation, and I think that we have significant, appropriate expert testimony. Not only do we have the pre-filed testimony, but the witnesses will be available for cross-examination and questioning by the board as well. So I don't think that this is an appropriate motion. I think that it should be denied.
I just want to reinforce what Dr. Coyle and the chair mentioned is that I do appreciate the concerns expressed by the town, and whether the power plant will cause adverse environmental impact will be a key issue that will be reviewed by the board in making the final decision. But I do think, as Dr. Coyle and Madam Chair Karan mentioned, that the board has sufficient information to base the decision on. I have a question from the town. Again, the reason why you filed this motion at this time because of the new water plan or something, or just for the whole project?
No, we filed it now because we were frustrated. We were frustrated by what we saw as incomplete information. And the final straw was when
From your expert?
No. Incomplete information being provided by Invenergy in response to the town's boards looking for information, and frankly, the entire process. And what really turned the tide for us was with the November 10th letter. When that letter came in and said DEM was suspending its review of the wetlands application because of 50 areas, and giving Invenergy a full year to correct its application, we said, well, you know, something needs to be done. And so we filed the motion.
Thank you.
Perhaps it goes without saying, but again, I'll repeat, it is the applicant's burden to demonstrate there's not an acceptable environmental harm. So if they don't do that due to insufficient information, there'd be consequences to that. But again, the experts that you've got some really excellent experts involved in this, and I look forward to their testimony as a way to base that decision.
You want me to make a motion? I make a motion to deny Town of Burrillville's request to hire an independent environmental impact document and appointing an independent environmental expert to review the environmental harms for this project.
Second. All in favor?
Aye.
Aye. That brings us to Invenergy's motion for protective treatment.
Chair. Thank you. This is a motion in regards to a confidential document that was attached to John Nyland's supplemental testimony. It's an ISO New England confidential document. It's the new capacity qualification determination notification that was provided. It is a document that is treated by the Federal Energy Regulatory Commission as confidential pursuant to approved tariffs and federal processes and rules there at that agency. We've requested protective treatment of that information for those grounds and recognition of the sensitive nature of the information contained within that document and the fact that it is treated as confidential by the federal agency and by ISO New England. We've requested protective treatment of that pursuant to Rhode Island General Laws 38-2-2, small paren 4 and paren B and paren 4 and S. Those are the exceptions to the Public Records Act, treatment of what is normally treated as public information. Those exceptions relate to the trade secret and commercially sensitive nature of the information, as well as the fact that it is treated as a confidential document by a federal agency. So that is the request that we put in. We're asking for that document, as well as the appendix to that document that we also provided to council, which is also the ISO stamped confidential document. And we're asking that the board treat those documents as protected for purposes of this proceeding. There's been no objection filed, and that's the nature of the request. Thank you.
Just want to be clear. Now, this is material that's attached to the supplemental testimony?
Yes. Yes, Madam Chair.
And is the supplemental testimony itself?
No, the supplemental testimony is all public information. That is my recollection. There were no redactions in the testimony itself. This request only relates to the ISO New England document that is designated as an attachment to the testimony. Or as an exhibit.
Is the entire document covered by the request?
I believe so, yes.
Well, and there's no objection to the motion. Given that there's no objection, I think we should grant that motion for confidentiality. It certainly falls within the ambit of materials that are routinely protectable.
And just want to confirm, and this information is classified as confidential by the federal agencies?
Yes, it is. It is treated as confidential by the federal agency. It is also treated as confidential by the ISO New England in its filings with the FERC.
Because of why it's treated as confidential by federal agencies? Because there's generally some reasons, right?
Yes. Yes, Commissioner. I think it's treated as confidential because the documents relate to an upcoming forward capacity auction that has not occurred yet, has not taken place. So it's a very competitive market. There are other businesses and other interest groups that really like to see the access to whatever the ISO New England is saying about this project, so as to evaluate how they are going to approach future bidding. So it's trade secret, commercially sensitive information. It's not information that's revealed to the public.
Thank you.
Is there a motion?
I make a motion to approve the protective treatment of confidential information requested by the Energy.
Second, all in favor? Aye.
Aye.
That brings us to the town of Charlestown. The first motion is the one for clarification / instructions and over extension. Is the town going forward on that one?
No, that makes sense.
Great.
It's based on the current circumstances of the final hearing.
Great, that's passed. So that brings us to the motion for funding as an effective.
Madam Chair, members of the commission, as I addressed to you previously during the town of Charlestown's motion to intervene, I struggle a bit with who is an affected community and how is it determined. Subsequent to filing the motion to intervene, I looked at that issue again with regard to this particular request before you, whether the town should be qualified as a community affected by the construction of this facility, and whether or not the applicant should be required to provide funding to the town in order to perform local environmental effect, perform tests and determine the local environmental effects of the proposed facility. What I can tell you again is there's no definition of who an affected community is in the statute. And clearly the facility again is struggling in the definition section of the statute because clearly the plant's not in Charlestown. But an essential element of the plant, I would argue an indispensable element of the plant under the current circumstances is the water supply. And even though it is not contiguous and connected, the fact that it's inseparable from the operation of the plant at this time, to me, makes it an indispensable element of the facility. And even though geographically separate should not be regarded as different there, proposal to construct a facility in the town of Charlestown. Now, because there's definitions lacking, I check case law and such, other authority, I can't offer you any. I'm not going to sit here and try to tell you there is any. I don't think there is a case on the subject. And I think as attorneys, we all know the general rule that when you don't have a definition, when there's an ambiguity, you look towards clear and ordinary meaning, you look towards the reasonableness of a statement to determine what does it mean? What is the legislative intent behind all this? And if you look at the critical terms here, affected by the construction, it simply means influencing or touching by an external factor. And clearly Charlestown is affected by this proposed construction. There's going to be a well, a filling station, a transfer facility, trucks coming and going. There'll be temporary impacts, long-term impacts. It is affected under any definition of the word. And again, all of this activity, these impacts, they are related to the facility. So again, I don't see how you can find them separate and different and not treat Charlestown the same as Burrillville. And lastly, I would suggest to the Commission, by your own actions and the actions of the applicant, it's essentially been an admission that Charlestown is an affected community. There was notice given to the community, there was a public hearing held under the statute as required. I would ask you to recognize that as an admission that we are an affected community. That's all I have for now. I'm not going to kill this. It is what it is, and I think we're either going to fit that box or not. I'd be glad to reply to any objections.
Objection?
Thank you, Peter, Madam Chair, and members of the board. In this case, we are looking at a statute that is not ambiguous in this instance. Mr. Ruggiero is referring to the beginning part of Rhode Island General Laws, Section 4298, 9.1b. This is the operative statute that we're dealing with. And I believe he's talking about having public hearings in affected communities. But if you go down to the third sentence of that statute, it reads, and I quote, "When the subject of the application is a facility for the generation of electricity or new facilities for the transmission of electricity, the town or city where the proposed facility would be located may request funding from the applicant to perform studies of the local environmental effects of the proposed facility. In this instance, it is not ambiguous. It talks about funding for the community where the plant is located. In this instance, Burrillville, and it is, and Energy has been funding Burrillville under this specific section of the statute. So in this case, this board, which is a creational statute, bound by the statutes which are listed, that is the operative language in this instance. Actually, the water in Charlestown is as we've been calling it, a backup to a backup. Johnston is still the primary source. The second source is Benny Water, and Charlestown is the third source. So in this case, I believe, and Peter, I won't read it to death, the statutory limitation limits this board's ability to require payment to any other entity other than the town that is hosting the power plant, which in this case is Burrillville. Clearly, the facilities in Burrillville, not in Charlestown. Charlestown is not the host community, and that the board is constrained by statute. Financing cannot be imposed.
It also seems that there is some confusion, at least, in the materials before us as to whether this contingent water source, which is the result of the contract with members of the Narragansett Indian tribe, about whether or not we're talking about wells in Charlestown or yet to be constructed wells in Westerly.
Charlestown, not Western.
So
That was in Energy's position. The ESS water supply plan that was submitted details only Charlestown. It was only
Yes.
Charlestown that we are dealing with.
however, one of the signatories to the agreement indicated that the intention was not that it was the wells on tribal land, but rather it was wells to be constructed with additional infrastructure on a piece of property that I believe the Narragansett Indian tribe essentially inherited.
I understand that letter was proffered at the last hearing that we had here. It was the first time we had seen that letter. It is and remains in Energy's position that to the extent that any water is taken under the contract with Narragansett Indians, it is from lands in Charleston.
And I just had another question about that. The Ben Water contingent agreement regarding water supply, that depends on all of the various water entities with which Ben has agreement. There are a number of municipalities as well as non-municipality water systems with which Ben has agreements.
That's correct.
And so that contingency involves a substantial amount of available water sources.
First of all, let me back up. I don't want to get caught up in terms of what agreements are out there that Ben Water has. But certainly Ben Water is the second source that we have, and that would be for the amounts of water that we have stated in our water supply plans.
And as far as you understand, Ben Water is capable, under whatever your contractual relationship, of supplying all of the necessary water for the facility without requiring fallback to any other contingent sources?
Yes.
And Chair, I had a question for Ms. Noonan too. I'm just wondering.
Microphone, please.
Oh.
Everybody?
It's just about 10:30, at which time we're supposed to shift to an open meeting and away from this hearing. We could make a motion on this and resolve it. I did have some questions, but I'm just mindful of the time. So I can quickly ask my question?
I think you should ask your question.
Okay. Ms. Noonan, on page 3 of your objection to the town of Charlestown's motion. You say Charlestown assertion that water for crack is proposed to be, quote, sourced, stored, transferred, and transported, sorry, Joanne, in the town of Charlestown is inaccurate. How is it that the assertion that water is proposed to be sourced in the town of Charlestown is inaccurate, especially given what you just said?
The primary source remains Johnston. That is our position. That it's incorrect to say that Charlestown would be primary, indispensable, inseparable. It is the Johnston source that is our primary source.
I understand that. I just have trouble given that if you needed the backup supply, as you just stated, as EFSB studied, the source of that would be Charlestown. Am I right?
Ultimately, if it came to the backup, yes.
Okay, I think you're distinguishing between the primary and the backup, but the point and the whole reason that we have the town of Charlestown here is that the contingent backup water supply would be sourced in Charlestown. Having clarified that, however, I think in this case, with sympathy for the town who needs to get involved because you are an affected community, I do read the statute to say that it's effectively the host community, and that when you look at the definition of a major energy facility and you look at that section of the Energy Facility Siting Act, I think we properly had the hearing in your town as an affected community, but I don't believe that you fall under the clear words of the statute when it comes to the community in which the facility is sited. So I would be prepared to make a motion to deny Charlestown's motion.
Is that the motion?
I move to deny Charlestown's motion.
Second?
All in favor?
Aye.
Now I would move to adjourn our hearing at 10:30.
Okay.
Second?
All in favor?
Aye.